We'll start with Law of Torts, but before that, right, you should have some general understanding on certain matters. So we are going to discuss that. After that, we will proceed with the topics that we have in the syllabus and other stuff. Okay, so what is law? What do you think is law?
Law is like there is no exact word, ma'am, to define that.
Hmm. But what do you understand when someone says law? What do you understand?
I have understood law is like supreme power.
Law is like supreme power. All right. So what is
Yes, ma'am.
law?
What I
Hmm. Yeah. So law is basically like a supreme power. We need to abide by it, right? If there is a law, we need to follow that. We cannot just violate it, right? Like if there is a law with regard to like COVID-19 that there are restrictions, you cannot go out, you need to obey that, right? You cannot just violate that law. So that is nothing but a law. What is law? It's rules or regulations that we need to follow. Alright, so whatever is written,
yes,
we
ma'am.
need to follow that. If they have mentioned that, okay, fine, after taking admission for LLB, you need to appear for all these papers. Only when you clear all the papers, you will get your degree, right? So that is a law. You need to follow that. You cannot simply say that I have taken admission, now give me the degree, right? You cannot say like that. Why? Because there is a law that mentions it, right? That you need to clear all the papers. After that only you will get the degree. So that is nothing but a law. And what is it? It is some sort of a rules or regulations that we need to follow. All right. So see if there is any confusion, any doubts in between, right? If you are not understanding, you can let me know, okay? Because all these topics are related to one another. Okay, it would be difficult for you otherwise to understand the remaining concepts. Okay, you can tell me. So, what is law? You understood, right? Rules and regulations that we need to follow. Is it clear?
Yes, ma'am. Yes, ma'am.
Okay. Now, why do we need to follow those rules and regulations? It's because we live in a society, right? There are so many people. We all will have different interests, different opinions, different understanding, different thinking. So you may like something, I may like something else, another person would like something else. Now, which one will we follow, right? So, in order to maintain uniformity and for us to be able to live in a society, right, we should all live in a society peacefully without fighting with each other, right? So, that's the simple reason why we need laws because we are a lot of people living in a society. We will have different opinions, different thinking, different understanding to maintain a balance, right? We need law. All right. So that is clear, right? What is law and why we need law.
Yes, ma'am. Clear, clear.
Okay. Now, what happens when there is a law? It will give you a right. Okay. Law gives some rights to someone and some duties to another person. All right. So what law gives is it will give some rights and duties. Okay, whenever someone is having a right, someone else will have a duty. Otherwise, you cannot enjoy your right. Take for example, like primary education is free, right?
Yes, ma'am.
Primary education in government schools is free. What is the age group? Are you aware of the age group?
14, ma'am. 14.
Yes, from 6 to 14 years, it's free. Now, why is it free? It is because there is a law with regard to that. Okay, there is a law that was passed in 2002, I guess, with regard to this that provides for free and compulsory primary education to children between 6 to 14 years. That means this law is providing for a right? That 6 to 14 years children will get a right to get free education. Now, simply having the law is not enough, right? I can write whatever I want, I can get it printed and say this is the law. But will the children be able to enjoy that right? They will not be able to enjoy that right until and unless someone has been given some duties. All right. So, what is that duty? Who is having this duty over here? Can you tell, if children are given this right that you have a right to get free and compulsory primary education, who will have a duty in this case?
Ma'am, can you repeat?
Take for example, under a law, children are given a right that you have a right to get free and compulsory primary education. Who will have a duty to provide that free and compulsory education?
Government, ma'am.
Government will have, right? So government has, like, there is education department, right? There is education department, there is inspector of schools, there are different government schools, then there are teachers in those schools. So all these people will have a duty. What kind of a duty? That they need to ensure that children are able to enjoy this, right? Alright, so understood till this much, right? What is a law? Law is providing for some rights and obligations. Alright, now
Yes.
what is right, you know anyways, right? Right is like an entitlement. If you have a right to free and compulsory primary education, you have that right, you can claim for it. If you have a right to vote, you have that right. After attaining 18 years of age, you can give vote, right? So that is nothing but a right. Now, rights are of different types, okay? Depending on what kind of a right you have, they are been divided into different types. One of which you need to know is right in rem and right in personam. Alright, we need to know what is right in rem and what is right in personam. We need to understand this because it is related to some of the topics that we are going to study. Alright, now what is right in rem, we will see. What is right in rem? I have even given it is available against the whole world. That means, okay, fine, when there is a right, there will be a duty. If you have a right, the entire world will have an obligation. Okay, the entire world will have a duty. Can you give any example where you have a right, everyone else is having a duty? Or a right when you have a right and some specific person or a group of person is having a duty? Any example that you can think of?
Education right.
Education right. So that is right in rem
Lots
or
of.
right in personam?
Yes, ma'am, lots of here. Most important thing is education right.
Alright. So you have right to education. Now you will have this as right in rem or right in personam.
Sorry, ma'am.
Take for example, you have right to education. Alright. Like take for example, you have taken admission in KSLU. Alright. Now you have a right to get education and get degree. Okay, now what kind of a right is it? Is it right in rem or right in persona? First, we will understand what is right in rem and what is right in persona. Right in rem is something which is available against the entire world. That means you will have a right and the entire world, all the other remaining people will have a duty. Okay, take for example, you are owner of a plot of land. Alright, you are owner of a plot of land. Now, all the other people in this world have a duty that they do not enter your plot of land, they do not disturb you in enjoyment of the plot of land and all that other stuff. Right? So, this is nothing but right in rem. You have a right, and all the other people in this entire world, they have a duty that they should not enter your property without your permission. Alright, that is nothing but right in rem. You have a right. All the other people in this entire world will have an obligation, a duty to ensure you are able to enjoy your right. Is it clear, right in rem?
Yes, ma'am. Yes, ma'am. Because that property is our for it's mine. So that's why they
Hmm.
more down the right.
Yeah, if you are the owner of the property, you only have the right? I cannot just enter your property and be like, okay, I want to plant a mango tree or something. I should not do that, right? Why? Because you
Yes,
have
ma'am.
a right being owner of the property. So that makes it a right in rem. That means apart from you, no one else in this entire world should violate your right. Right? The entire world will have an obligation, a duty to ensure they are not violating your right. Okay, so that is nothing but right in rem. Is it clear?
Yes, I'm clear.
Alright, next one is right in personam, which means it is available against specific person or specific group only. Okay, that means fine, you have a right, but this right is available against a specific person only. Take for example, I have a book. Alright, I have a very good book for Law of Torts. Alright, what I am doing is I told you, okay, fine, you want to prepare for your exam, you can take my book for 1 week. Okay, you can take my book for 1 week. You prepare your notes, you study from it and everything, and after 1 week, you return this book to me. Alright, now I have a right? Take for example, this is the book. Okay, I am owner of this particular book. I gave you this book for 1 week. After 1 week, I have a right to get my book back. Right? I have this right. But against whom I have this right? From whom I can claim this book?
Because this book is yours, ma'am. So that's
Yeah.
why we
Hmm.
have a right to ask them.
Yeah. From whom can I ask?
From whom have taken this book?
Yes, right. If I have given this book to you for 1 week, after 1 week, I can go to you and ask you to return this book. That means this is right in persona. Right? I definitely have a right to get back my book, but I simply cannot go randomly any person. I cannot say, oh, return my Law of Torts book. I cannot say that, right? It will be against this specific person only against whom I have a right. So that is nothing but right in persona. Alright, in both the two cases, I have a right. In one case, against entire world, I have the right. In another one, against specific individual or a specific group only I have, and to them only I can ask for this right. Alright, is this part clear? Any confusion until here?
No doubts, ma'am. Cleared.
Now, so if you have got enrolled in KSLU for LLB course, you have a right to get education and right to get a degree. Is it right in rem or right in persona?
Right here, ma'am.
Hmm?
Right here, ma'am. Because I have got a admission
Which right? Right in rem or persona?
to ask them to get a good education.
Yeah, that only. Like, under which one it would come? Is it right in rem or right in persona?
I think right in RAM.
Right in rem. Is it? See, here I
Ma'am,
got
I
an answer is specific group or person. If you have taken admission in KSLU, can you go to Karnataka University and say that give me my degree? Can you go to Pondicherry University and say give me my degree? You cannot, right? If you have taken admission in KSLU, you have a right against that university only. You can only ask KSLU that I have appeared for all the exams, I cleared all the exams, now give me my degree. So it is right in personam. It's against specific group. KSLU University only you have a right. You randomly cannot go to any university and then ask for the degree. Right? So it is not right in rem, but it's right in personam where you have the right available against one specific person or it may be a group of person. So KSLU becomes a group of person. But if I lend you my book and then I ask you to return this book, in that case, it becomes right in persona against a specific individual. I have this right. Is it clear?
yes, ma'am, clear. Ma'am, I have a doubt.
Hmm.
Generally, I will asking. Generally, I am asking you,
Hmm.
ma'am. If you give a book to me,
Hmm.
we have a right to return,
Hmm.
to ask return.
Hmm.
I will ask you, what is the proof?
Hmm.
Then what, ma'am? What will happen?
See, for books, right, it would be maybe my name would be written or I have some track records. Usually, people do not lend books like that, right? You would otherwise lend a book from library. They would have all the records and everything, right? When semester exam is nearing, they would say that until and unless you return all the books, you are not entitled to appear for the exam. Like that, they would say. Mostly in between friends, it's depending on good trust and everything they would lend. All right, there we are not like maintaining a register and all that stuff. It's only because I have trust on my friend I would be lending that book. If I do not trust a person, I would not lend the book. Simple as that.
Yes, ma'am.
But for
It's depend
library
on trust.
hmm?
It's totally depend on trust, ma'am.
Yeah, it is totally dependent on trust, and mostly we do not maintain any register and all that other stuff. Maybe someone might be there who was there, who saw as a witness, they saw. Some evidences might be there, but otherwise, in between friends and known people, we do not maintain such kind of registers and other stuff. But it is mostly in case of libraries that you would see, they would maintain everything. And if you do not return the books, you are not entitled to appear for the exam. You will not get your degree. You would not get your certificate and all that things. So people would return anyways. All right. Is
Yes,
it
ma'am. Got it.
all right? Now, for law of torts, right? What happens is we are not concerned with murder, rape, or like robbery, theft, other stuff. Those are criminal. Okay, you would get those under IPC, then Evidence Act, then CRPC. All right, under those laws, you would get those offenses. Also, you would get those examples. Also, all right. Now, because we have a basic understanding with regard to this, right? What is civil, what is criminal, what is a law, why do we need a law? We have a basic understanding, right? Now we can start with what is law of torts. All right. So we'll just see what is law of torts. Now, what is law of torts? The term tort is derived from a Latin word tortum. Okay, you need to remember the spelling as well, and you need to remember this part because there will be a question from your first unit, right? You can give this thing in your introduction that the term law is derived from a Latin word tortum. You need to remember the spelling as well. What is tortum? Tortum means twisted, crooked, or what is not straight. Now, what is not straight? What is twisted? What is crooked? Take for example, being member of a society, we are expected to behave in a certain way, right? Take for example, I live in a society, I stay in Karnataka. All right, I'm from the state of Karnataka. Now, being a resident of Karnataka or being a resident of India, all right, I have certain certain rules or regulations I need to follow, right? There is a basic sense of how I need to behave. All right, there are certain things that I should not do. There are certain things that I can do. All right, take for example, I am a person residing in India. I am residing in Karnataka and I love mangoes. All right, I love mangoes. Now, I was going to my college one day and I saw there is like a big mango tree. Alright, there is a big mango tree at someone else's property. Alright, at B's plot of land. Now, B's plot of land, there is a big mango tree with ripe mangoes and everything. Now, am I supposed to just go pluck mangoes from there and then start eating it? Will I do it or is it justified to do like that?
No, ma'am.
No, right? Why is it not right? Because that is not how I am supposed to behave. Right? So that is nothing but what is not straight. That means I am supposed to behave in a certain way. I cannot just pluck fruits from a stranger's place and then start eating it. Right? That is some defined rule is there, right? We know we can do this, we cannot do this. If we do the opposite, right, that becomes a tort. That means being member of a society, there are certain things which we can do, there are certain things which we cannot do. If we violate that, if we do those opposite stuff, that I'm just going randomly there plucking mangoes and eating them, then maybe I love gardening, I love to plant like seeds and everything, but I do not have much of place at my house. So what I do is I go to someone else's house, open the gate, and start just planting a tree. That is also not right. Why? Because all those are not how we are supposed to behave. All right. So all of those becomes a thought. Okay. So what is thought? It is something which is not straight. It is something which is crooked, which is twisted, or how we are not like expected to behave in a society. All right. And tort is what? Tort is a civil wrong. Because if even if I am plucking trees from B's plot of land and eating it, even if I'm going to C's place and planting trees, you would not be bothered about it, right? You would be like, oh, okay, fine. Maybe she did not know that, or maybe something like that. You would not be much concerned with it, right? That means these are certain wrongs which are not very severe, also, that everyone would be affected by it, everyone would be concerned about it. All right, maybe in your life also, right? In your life also, you have seen, might be your neighbors, you have seen that they are just plucking flowers from others place, maybe someone is plucking fruits from others place. Have you seen any examples like that?
Yes, ma'am. In front of our land, ma'am.
Hmm.
Beside, ma'am. Beside. I have seen, ma'am.
You have seen.
Few people, yes, ma'am. Few people were plucking the flowers, ma'am.
Yeah, that you have seen. But now, when we were discussing in class today, you were concerned with that politician raping a girl and then not getting a punishment. You were concerned with that. But you were not concerned with someone plucking flowers from your neighbor's place. Why? Because this is very less severe as compared to this one. Right? That is what I was telling you. That criminal is very much serious, civil is less serious. You have seen many people plucking flowers, fruits, and other stuff, but you would be like, okay, fine, people just do it, can't help it. Right? You are not bothered with it very much. But in this particular case, you are so concerned that you are asking, like, is it this only that happens? Why? Because it's criminal, it's more severe. And this one is civil, it's less serious. Alright, you understood the difference, right? What is civil and what is criminal? How society is affected by it.
Yes, ma'am. Got it clearly.
Yeah. So that is what tort is. Tort is less severe and it is a civil wrong. Where you might have seen many such examples, but you are less bothered about it. When we discuss other types of torts, right, that time also you would be able to relate with all these different examples that, yeah, this is something that I have seen. But maybe you have not bothered that much. Why? Because it's less serious. Alright, so tort is what? Tort is a civil wrong and you need to remember it. Alright. So now this becomes a tort that if I just walk in someone's plot of land, start plucking mangoes or start planting a tree, that will become a tort. Another example maybe you are owner of a plot of land. I do not know you. You have not invited me to your place, but simply I just walked inside, opened the gate, opened the door, and then I just went inside your house. That also becomes a tort. Alright? Because you are owner of that plot of land and I should not enter someone else's private plot of land. That also becomes a tort. Alright? Then take for example, uh, like it's usual, right? Around 10 or 12 o'clock, people would go to sleep. At 2 or like 2 a.m. at night, if I just start playing loud music with speakers and everything, my neighbors would be affected, right? They cannot sleep peacefully. I am creating such a noise that my neighbors are getting disturbed. That is also nothing but a tort. All right. Take for example, I am just like installing a meal or a very heavy machine inside my house. and just grinding some wheat or other stuff. It is creating lot of vibration. My neighbors are getting disturbed. That is also nothing but a tort. Alright, so these are some examples of tort, that we are supposed to behave in a certain way, we are doing the opposite. Right? It's a twisted behavior. It's something which is not straight. So that is nothing but a tort. Alright, so what is law of tort? Is it clear?
Yes, ma'am. Yes, ma'am.
Okay, so now talking about torts, it is derived from a Latin word called tortum, which means twisted, crooked, or what is not straight. Now, when we talk about torts, like as members of a society, we are supposed to behave or act in a certain way. Okay, something is, we know that this is how we should be behaving, right? Like might be I'm walking to my office, if I see some ripe mangoes at my neighbor's place, I would not simply walk inside, pluck the mangoes and start eating it, right? I will not do that, because I know how I'm supposed to behave in a society. But if I'm not doing it, I'm behaving in a different way, I'm behaving in a twisted or crooked way, or behaving in a way how I'm not supposed to behave, that is called as tort. Okay. For tort, there are again 3 elements that we need to satisfy, but in general, this is what tort is. If I'm behaving in a different way, how I'm not supposed to behave. When we talk about torts, it is a civil wrong. Some examples are negligence, nuisance, trespass, etc., which affect private rights of individuals. As in, it's not rights of an entire community, entire, like all the population of India or something, but it is my rights, maybe my family's rights, or maybe 2-3 persons' right. Like that, it happens mostly in case of tort. Okay, then there are some definitions. Definitions you need to by heart it. There is no other option, because whenever there is a definition, you need to write it in the exact same way, right? You cannot do modification. So these are 4 very simple definitions. You can try to memorize these definitions. Okay. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way, topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. So when we talk about torts, tort is a civil wrong, understood. Contract also, as I told you, it is a civil wrong, right? There is a contract between 2 persons. There is a violation of the contract. But then why do we have 2 different subjects then? Why do we have contracts and then we have law of torts? It is because there are some differences between them, even though both fall under civil wrong. Okay, so what is the difference? We will see that. When we talk about torts, it is what? It is breach of duty which is fixed by law. As in, when we talk about torts, yes, I'm violating my duty. I was not supposed to enter my neighbor's premises, start plucking mangoes and start eating them. I had a duty not to do that, but still I did. But who fixed that duty? It's not something which is fixed by me and my neighbor, but rather it is fixed by law. Right? Law tells me that this is wrong, this is trespass. You should not be entering someone's plot. That means it is the duty which is fixed by law. That is what tort is. Duty is fixed by law, we are violating it. As a result, some person or some group is suffering. When we talk about contract, what is it? There also breach of duty is there. But what kind of duty is it? It is fixed by the contracting party. Yes, we do have a legislation altogether called Indian Contract Act. But when you look inside it, it is not saying that this is what is your duty, this is what the other person's duty. It simply tells this is how you can enter into a contract. This is valid, this is not valid. That much. That means whatever duties we have under a contract, it's discussed and negotiated between the parties and they fix it. So that is the difference. Both are breach of duty. This one is fixed by law. This one is fixed by contracting party. Okay. Then, as I said, compensation. Compensation is also called as damages. All right. So damages is very common for both tort as well as contract. When we talk about damages in case of tort, we do not know what may be the amount of harm that we may suffer. As a result, it is unliquidated, as in it is not prefixed. Yes, we can get damages for negligence, nuisance, trespass, and all that. But maximum and minimum limit is not fixed. Okay, it is open. Court will decide depending on the situation, depending on the parties involved. It is called as unliquidated damages. Try to remember it, which means not prefixed. Depending on facts and circumstances, court will fix it. Okay, recently, last year, I guess there was a case where there was a model, okay, she was working for some hair brands, okay, like she was having long hair and stuff. She used to work for all these shampoos and stuff she used to promote. So she was having some interview. Before the interview, she thought that I'll get myself groomed. Okay, she went to a parlor to get a haircut and some hair treatment done. But that was some issue was there. Okay, it was not properly done. Some treatment was not proper. So she started suffering some, you know, like scalp issues, this, that, and everything. Her hair started falling off and everything happened. She filed a case in the court, I think, asking for some 4-5 crores or something, and court gave her 2 crores for a bad haircut and a bad hair treatment. She got 2 crores. Why? Because it ruined her entire profession. Because of that, she went into depression and everything. Why? Because that was what she, you know, like her entire career and everything was based on. That's why we say it is unliquidated, depending on facts and circumstances. If a normal person like you or me go and claim, court might say that, okay, fine, 5,000 rupees compensation you are getting. Because it does not matter, right? Hair would grow again. It does not matter. But because for her it mattered, she got 2 crores compensation. So court says that we do not know tomorrow what might be the amount of loss you may suffer, what may happen. So there is no maximum or minimum limit, because we do not even know who might infringe our rights, right? Who may cause nuisance, trespass, and all that stuff. So it's not prefixed. Try to remember this word, very important. Again, we say damage. Damage as in loss, harm, etc. Right? When we add one S, it's not multiple losses or multiple harm, but it means damages as in compensation that is being paid.
Okay.
Okay, that you need to remember. When we talk about contract, mostly what happens, we know who is the other party. I am entering into a contract with you. I know if you violate the contract, what may be the maximum amount of loss I might suffer. Right? So mostly in case of contract, you would see parties decide on a value, that this is how much should be the compensation or this much percentage, because they have an idea if this contract is violated, this might be the amount of loss I will suffer. Mostly in case of contract, damages are prefixed. Parties do mention it, that this is what we are going to compensate each other. Okay, that is again one point of difference.
Ma'am, I didn't understand this point. I'm sorry. In contract, damage are fixed according to terms.
Okay, I'll tell you. Have you heard of bond agreement that people sign while joining a job?
Company, yes, ma'am.
Right. So take for example, there is a person. Okay, take for example, there is a person who is an engineer. He has just completed his BE. He is not having any experience or anything. There is a company who is ready to hire him. But because he do not have any experience, he actually cannot perform any work for the company. So company says that, okay, fine, we are hiring you for 50,000 rupees. Okay, you will be getting 50,000 rupees salary per month. But
because you do not have any experience, for the first 1 year, we are going to give you a training. And this training that you will be getting, that is very expensive training. It is 2 lakhs rupees. But you don't need to pay anything. Company will be paying 2 lakhs rupees for your training. And during this 1 year of training, you will be getting your salary also. So 50,000 into 12 plus 2 lakhs. That much amount company is investing
Spending on me.
Yes.
Yeah.
After 1 year, after completing the training, what if this person says, I'm resigning this company? Company is going to suffer a lot, right? So mostly they would say you need to sign 3 years bond. That for 3 years, you are not going to resign this company. And if you are doing how much you need to pay, you need to pay 6, 7, 8, might be 9 lakhs rupees you need to pay because of the time we have invested in you, because of the money we have invested. Okay, that is nothing but company knows if by chance this person leaves the company before 3 years, what amount of loss we are going to suffer. 50 into 12, 6 lakhs plus 2, 8 lakhs we are going to suffer. So let us mention 9 lakhs you need to pay. Right? So we mostly have an idea. So most of the times it is fixed. In case of bond agreements, it is fixed. In contracts also most of the time some limit would be there. Okay, that is why it is called as liquidated, but this one is unliquidated damage. Okay.
Okay.
Is it clear?
Yes, ma'am. Clear now.
In tort, duty is bound towards the society at large, but in case of contract, it is to specific person. Like in case of
but one second, 1 second, ma'am. In breach of contract. So what? So imagine we both have a contract now, some contract. In that we can't fix, right? See, example, we will take what's happening between us now. Like, see, I'll pay you money and say that, ma'am, I need tuition classes. So now there is a contract between us. Okay, I'll pay you money and you don't take the classes. But we never had a agreement saying, the contract saying that, ma'am, if you don't take the class, you have to pay me 50,000. We never fixed it. So, but in this case, again, this is, what is this called? Unliquidated also comes in breach of contract, right?
Actually, see, this is not like a formal contract we have. I'm talking about companies which are entering into contract. There you would see like professional contracts that are there, right? There will be a clause relating to compensation, limitation of liability, that only this much I am liable, like that you would say. Obviously, there are so many other informal contracts that we entered into. There no liabilities there. Their court would say that, okay, this is how it happens. But talking about those formal professional contracts, there always you would see that provision will be there, only limitation of liability, compensation, it will be there. They don't want to take that risk.
Okay. Yeah. So this is different type of contract. This comes under formal contract, especially
formal contracts mostly. There you would see kind of provisions. So in case of tort, duty is bound towards the society at large. If I am living in a society, I am bound not to enter into any random person's property. It's not about just the person having a mango tree, but any person I should not be entering. Right? So it's a duty is bound towards the entire society at large. Entire society is not supposed to enter anyone's property, right? All of us are having a responsibility. When we talk about contract, it's the specific persons. Only if I have entered into some contract with someone, I have an obligation only to that specific person, not to the world at large. Okay, so that is also another difference which we have. Okay, law of tort and the principle of tortious liability are a result of precedent or principles involved in case laws or judicial pronouncement. We don't have a legislation called Indian law of torts or something. We don't have a legislation. All these concepts are developed as a result of different cases coming in. Okay, a case came before the court and court realized that, okay, might be we should have something like this, and an entirely concept developed. Okay, one example is one gas leak case, MC Mehta versus Union of India, wherein Supreme Court developed a concept called absolute liability. You need to pay compensation to those who have suffered loss. Like that, as a result of different cases, different concepts have developed, mostly foreign cases, as a result of which we have got a lot of different concepts. Okay.
Hmm.
So it is called as law of tort is not codified. As in, it's not like written in a statute or something. It has developed with time.
Hmm.
But contract is a codified law. We have a legislation called Indian Contract Act that tells us about the rules, regulations we need to follow to enter into a valid contract. How contract will be performed, everything is mentioned in this one legislation. In tort, damages may be compensatory or even exemplary damages may also be awarded. But in case of breach of contract, damages is always compensatory. As in, court feels that, okay, fine, you have suffered this much of loss. This is the compensation for you. Okay, that is in case of contract. That this employee is resigning before completing the bond term. This is the compensation you need to pay. This is compensated damage. You compensate the loss that the person has suffered. In case of torts also, we see compensatory damage being provided. Sometimes it is exemplary damages also. That means extra amount is imposed on the person just to make him realize that what you have done is not good. Okay, it might happen that court has imposed 10,000 rupees compensation. And 10,000 rupees is nothing for that person. In that case, he would feel that thing, right? That, okay, I have done something wrong. So in some cases, exemplary damages are also asked by court that this is what you need to pay. Okay, so that the person realizes the mistake. So that also we get to see in a lot of cases as well. Okay, so that is how tort and breach of contract, they both differ even though they are considered as civil wrongs.
So this last point says, if I'm leaving a company, though there is a contract for 3 years, if I'm leaving before that, as it is mentioned before, only 9 lakh have to pay. So there is no chances of asking for more than 9 lakh. Not more than 9
again,
lakh.
if you are stealing some property from the company, if you have caused them some extra damage, you have misbehaved with someone, it adds up. Yeah, depends on the situation, what you have done actually. Is it that you are simply saying politely that, okay, fine, I'm just terminating the contract, or how are you doing it? Right, that depends.
Okay.
Okay, so this thing you need to remember. Damages means compensation. Damage means the loss suffered. Okay.
Okay.
What is liquidated?
Fixed amount.
Yes. Not liquid, non-liquid, unliquidated. This is not prefixed, but this is
not prefixed. Prefixed. Yeah.
So these are some things that you need to remember. Okay. Also, in between a sentence, if you are writing act in small letter, it means action. That your act, your action. If you want to mention about some act, like if you are mentioning too many times Indian Contract Act, Indian Contract Act, Indian Contract Act, and then you want to say the act. In that case, A should not be small, A should be capital, because you are referring to a legislation.
Particular act.
In between a sentence, you need to write it in caps because you are referring to a legislation. So these are 3 things you need to remember, very important.
Okay.
Okay, is this part clear? Any confusion?
No, I'm cleared, ma'am.
Okay. Right. So civil and criminal, we have already seen the difference. Tort and crime is also something similar, because tort is civil wrong, crime is criminal again. Right. So what is the difference between tort and crime? Tort is a wrong that infringes private rights of individual. It is affecting rights of those specific persons. If it is a landlord and tenant dispute, it's affecting rights of that specific landlord and the tenant only. When we talk about crime, it is breach of public right. Why public right? Because society is having a responsibility to ensure our safety. When it is violated, the entire population gets affected.
Society is failed,
If there is a murder taking place, we all are afraid, right? We think that, okay, is it that easy to kill a person? Right? There are protests going on. We need justice, this, that. But that does not happen with a civil wrong. Right? So that is how the difference is.
Okay.
In case of civil, compensating the plaintiff is what they aim at. That whatever loss you have suffered, we try to minimize it, because we cannot undo what is already been done. But what we can do, we can provide you some compensation to reduce the loss that you have suffered. Mostly you would see in case of accident cases, motor accident cases. Parties would go to court and they will claim for the medical expenses. So what is it? That's some relief, at least medical expenses, the other.
Minimize the wrong happened.
Yes.
Something like that, no? Yeah,
how much
minimize the loss.
Otherwise suffered, that is minimized. That is brought.
Yes, ma'am.
In crime, the main aim is to punish the accused if convicted. If his guilt is proved, court will try to punish him to teach him a lesson that this is wrong. You should reform yourself into a better human being. Also, this acts as an example for other like-minded people, that if you commit something similar, you are also going to suffer. In case of tort, intention might not be relevant in all the cases. Whether your intention was good, bad, does not matter. You have caused loss to the other person by playing loud music, by driving with, like carelessly. That is what matters. That you, because of you, other person has suffered loss. Now you compensate. Does not matter.
And what is omission? What is omission actually?
Omission as in not doing something. You had a responsibility, you failed to do
it. And failed to do it. Okay. Yes.
Okay, like doctors, if you are going to a doctor, doctor should straight away not operate you. Doctor would ask you for some test, etc. Doctor would ask you about your previous medical history, if you are suffering from any health issues, right? If doctor fails to do that, straight away says, okay, come to the operation theater, directly operation. After that, it turns out person was diabetic patient and wound is not healing. That is omission from the doctor. Doctor failed to perform his duty. Okay, when we talk about crime, intention is most of the times very much relevant. If intention is not there, bad intention is not there, sometimes it's not even considered as a crime. Like theft, intention is very much needed there. Like that, it happens.
Okay,
because intention is required, right? Because we think that the person has done something wrong, we want to reform him. If bad intention is only not there, what do you reform? Right? Punishment doesn't make sense there. In case of tort, a suit is brought by the individual whose right is being violated. If it's you and me, we both would go to the court. In case of crime, you would mostly see state being a party, because it's as if state's right is being, like state failed in its duty because of the criminal. In case of
I'm sorry, repeat this 2 point. In tort, a suit is bought by the individual whose legal right.
Like I said, right? It is the person, two persons, two organizations, like that. In case of criminal, you would mostly see the state being a party. State or union.
Okay. Understood. Both the point understood. Yeah. In this, the state involves. Yes. We discussed this.
Yeah. So tort is tried in a civil court, and definitely crime is tried in a criminal court. So these are the differences which we have for tort,
civil and criminal court.
Crime. Yeah.
Okay.
This is like tort and crime. Previous one was like civil and criminal, and this is tort and breach of contract. Okay. 3 differences we discussed. After that, we have essentials of tort and all that provision we have. So we will continue with it in the next class. Okay. So there is entirely like one topic on Ubi Jus Ibi Remedium. Okay. Now, when we talk about rights and duties, what is a right? Right is nothing but like entitlements, right? If you say you have a right to enjoy a certain property, as in you are entitled to enjoy the property, you can sell it, gift it, live there, whatever you want to do.
Yes, ma'am.
You have not studied jurisprudence yet, right?
Yes, I have studied, but not in deep. I think first, like briefly, I've read, not in deep.
So in jurisprudence, you get a concept called rights and duties. Okay, when we talk about rights, it's not that rights simply exist of its own. There has to be a duty also. Okay, it's said that rights and duties are like 2 sides of the same coin. Like one coin cannot have only one side. If you are having a right, someone else has to have a duty as well. Okay, so rights and duties are correlated. Both the things will exist together. Every right has a corresponding duty attached to it. Just like how a coin is having two sides, just like that, we have rights and duties. Take, for example, if the state has given right to life to a citizen, it also constitutes corresponding duty. That is duty not to deprive others, right? Like we have laws under IPC, right? Like murder is a crime. Why? Because we are been given right to life. For us to be alive, other people are restricted, that you cannot simply go and kill a person. That is a crime, right? So if you are to enjoy right to life, all the other people will have a duty not to kill you or not to infringe this particular right, not to violate this particular right. Okay.
Yes.
Same ways, if we talk about right to free and compulsory primary education, 6 to 14 years in government schools, simply saying that kids between 6 to 14 years are having right to free education, that's not enough. Someone has to be there to provide the free education, right? So government has imposed the duty on education department, teachers of government school, administration of government school, inspector of school, all these different bodies, that you have a duty to provide free education to kids between 6 to 14 years. So whenever we talk about right, somebody or the other will be having some sort of duties attached to it. Thus, if a right which is recognized by the state is violated, then state also provides for a remedy. It's not that simply it's saying that, okay, you have this right, that right. That's not enough. Some remedy has to be provided, and that is explained with the help of this legal maxim, Ubi Jus Ibi Remedium, which means where there is a right, there is a remedy. Okay. And when we talk about right, it's nothing but a legal right. Law has given you a right. That means there is a remedy as well.
Remedy. Okay.
Now we have limitations of Ubi Jus Ibi Remedium. This maxim does not apply to moral and political wrong which are not actionable. If there is something which we say that, okay, it's morally wrong, it applies to legal rights only, right? It's not that morally something is correct or not. Like if there is a person who is owner of a bakery, okay, he's having a big bakery shop. There are a lot of some pastries, cookies, this, that stuff. If a beggar comes to him saying that I don't have money, but please give me something to eat, I'm very hungry. It is only a moral duty of that person to offer food for free. But he is not having a legal duty, right? If he is saying that, no, I can't provide you anything for free, there the person will not ask for a remedy.
Correct.
Okay, so it applies for legal rights only.
Okay.
This maxim is not applicable to those cases in which proper remedy is given in case of breach of right under, in cases in which proper remedy is given in case of breach of right under common law. So there are certain cases where you might be having, like some laws are not codified, like in case of torts, it's not codified. With the help of common law, like with the help of case laws coming in, with the help of different judicial precedents, things has come, right? So in such cases, we need to see what was the precedent, what has court recognized, or what has this certain case law recognized, and based on that we look at the remedy. It might not be that it's written somewhere properly that this is a right, this is a remedy, but it's understood from the judgments, previous decisions that are existing for that. Okay. Precedent, you know, right?
Ma'am, the second point, this maxim is not applied to those cases in which proper remedy is given in case of breach of right of under common law. So, like
common law, common law as in something which is like judges play more active part. Okay, like in case of torts, okay, it's not somewhere written, it has developed with time, with different cases coming in. Okay, it is called as like common law. Okay, in England it has basically developed and we also adopted it. But in case of IPC, everything is properly written, right? This is a crime, this is the punishment. So in these cases, what happens is proper remedy is given in case of breach of right under common law. In common law, we have something established. There are cases, it talks about it. So based on those case laws, we will follow. It might not be properly written in the form of a statute like we have IPC and stuff like that. Okay, so common law is like, it's not how we have IPC.
Can you please give me any on at least imagination example for this, like how the previous point, how you gave the imagination explanation, like how
for example, there was one very famous case where like something called as mental shock. Okay, mental shock was not previously recognized as a kind of tort. Okay, mental shock was not previously recognized as a kind of tort. There was a case downtown, something name I forgot. It's there. I mentioned that on YouTube also. It's a very interesting case. What happened in that case? That was the first case which recognized this entire concept. Okay. One person came and he was just cracking a joke in front of a wife. Okay, so in front of somebody else's wife, he was cracking a joke that your husband met with an accident. He is there lying on the road helpless, and his, I think both the legs separated, something. Okay, very bad joke. And the wife came under such a shock, and he said that, okay, you need to take 2 pillows to support his leg, and he is like calling you, you should take a cab and just go there. She came under such a shock that her hair started falling, it started becoming gray. She had a lot of health issues and everything that followed. So as a result of that, this person was held liable. And mental shock for the first time was considered or recognized as a tort. Right? That means for mental shock also you get compensation. So how did this thing came? It came with the help of a case only, and now it's a well-recognized concept. It's included in tort syllabus also, but previously it was not there previous to that particular case.
Okay, ma'am.
So if there is no legal damage which can be caused to any person, then this maxim will not be applicable. So only when there is legal damage, there it applies. If there is no possibility of any legal damage being caused, nobody's right is being violated, this maxim is not going to apply. Only if there is a possibility that, okay, fine, someone's right may be violated, there only this remedy would be applicable. Okay, no remedies are available in case of breach of marriage vows or personal commitments, as these are the promises made without consideration and are based on trust. So in such cases also it's not applicable. But yes, there are personal laws where provisions are there to provide maintenance and all those stuff, right? But as such, we don't say that, okay, it is like a compensation for violation of a right, right? Parties are free to get separated, get divorced if they do not want to continue with a marriage, but we cannot say that it's like a compensation for the loss, but it's rather a way to support the spouse who is not financially independent even after the marriage. So it's not like a remedy that we have, remedy for divorce. It's not a remedy as such. It's just a support that has been offered by the court. Okay. This maxim is not applicable in case of public nuisance unless and until a plaintiff shows that he has suffered an injury more than members of the society. So these concepts we would actually be getting in other topics like nuisance. We have a concept. Public nuisance as in lot of, like maybe entire community or entire group of a society are suffering loss, like public is suffering trouble because of a nuisance. In such cases, if there are like 200 people who are suffering loss, you alone should not be going to the court saying, okay, my right is being violated. It's not just your right, it's actually right of the public. If you have suffered some extra or more harm, then that's a different matter. Otherwise, in case of public nuisance, usually one individual is not allowed. So that's also somewhere remedy might not be applicable because you have suffered the loss, but you have suffered along with a group of people.
Okay.
This maxim is not applicable where plaintiff is negligent or there is negligence on the part of plaintiff. You have suffered loss, agreed, The other person has done something wrong, agreed, but you also might have contributed, or maybe you were only someone who was doing wrong. Okay, you only entered somebody else's property without their permission. You suffered some injury there and you are filing a case. This person is not maintaining his property well. So court will ask you, why did you enter that person's property at the first place without being invited, without taking the consent, right? That means you only were doing something wrong. So in such cases also, you will not have a remedy. Okay.
Ma'am, if example, so like one person will enter, A will enter B place. So A is a, what is this called? Trespasses, okay. So B will hit him. B will hit A, but A will go to court saying that but court will ask him, does court ask A, why did you enter his place?
See, it depends on what was the amount of force being used, because we have a concept of self-defense. Was that beating necessary? Was it with bare hand? Was it with a wooden stick? What was the level of force being used? So court would see all those factors. Okay, reasonable force you can use.
Okay.
Yeah.
So again, so many aspects will come under the picture, like as you said.
Yeah, all these different laws are like related to one another. Okay.
Another part of the law, yes, ma'am.
Yeah. So there are some ingredients that we have. Okay, first of all, we have there must be a right which is recognized by law. Your right is being violated and it should be a right which is recognized by law, legal right. Violation of such right, a right was given to you by law, that right was violated by someone which resulted in damage or loss, or maybe violation of that right is only enough. Okay, so first of all, a right which is recognized by law. Secondly, violation of that right. Thirdly, remedy should be for damages. Some damages or some compensation, some relief has been provided. The nature of the act varies from situation to situation. What did the person do? How was your right being violated? Those things depend on situation to situation. There may be a lot of different situations that might take place wherein a person's right is being violated. Okay, so court would see, were you given a legal right? Was your right being violated or not? Right, and because of that, what is the remedy available? Court would accordingly try to provide you that, like the best applicable remedy, court would try to provide you. Okay.
Provide me. Okay, ma'am.
So Ashby versus White, we have already discussed. He was not allowed to vote. That means his right was being violated. Court gave him compensation. Him Singh versus State of Jammu and Kashmir. MLA was not allowed to take part in legislative assembly, so he was given compensation, right? Same ways we have these two more cases. We will see it.
Yes, ma'am.
Okay.
And in exam, how many cases I have to write, like for every?
That depends on your writing speed, marks in the question. A lot of factors are there.
Okay, so the more I write, there are chances of getting more marks, something like that.
Yeah, but then again, it should not happen that you are simply like writing one answer, and 2 hours gone, and you are skipping questions. So first preference should be answering all the questions. After that,
correct. Okay.
The content.
That is all about time management there. Okay.
Yeah. So next case we have is Marathi versus Williams. The defendant was the owner of a bank, and the plaintiff had an account in the same bank. The plaintiff had sufficient funds in his account, and when plaintiff went to the bank and he deposited a check, he wanted to honor a check. The defendant refused to honor the check to him. The court held that the defendant is liable for the loss caused to the plaintiff. The court applied Ubi Jus Ibi Remedium, as the plaintiff has a legal right which was being violated. If a bank is there, bank is supposed to clear the check if there is no issues with the signature, amount or something like that. If the check is proper, you clear it. If something is incorrect, you mention that to the other person. You cannot decide that, okay, this person is having sufficient fund. What is sufficient fund, right? We cannot define that. It varies from person to person. So this person being the account holder in the bank, he has a right to ask to honor a check that he is having in his name, and bank should recognize or respect his right. If that is not being recognized, it's also nothing but violation of his right only. Okay. Then there was this case, DK Basu versus State of West Bengal. Now, what happened in this case is, it was not like I mentioned, right? Plaintiff is usually the one who suffers loss. There is a concept called public interest litigation, PIL, wherein someone else can also file a case. Like maybe I am a person, I have not suffered any loss, my right is not being violated, but I'm a person who is concerned about the society or rights of certain people. Okay, and I feel that maybe they are not going to the court, or maybe they have not realized their right. I can file a case on their behalf. It is called as public interest litigation. A litigation or a case filed in the interest of public. Okay, as such, my interest is not involved. Same happened here. DK Basu versus State of West Bengal. Who was DK Basu? Okay. He was working as executive chairman in an organization, Legal Aid Services in West Bengal, which is a non-political organization. And he came across this issue, okay, certain news which were being published regarding this custodial violence that take place. We come across these news quite often. So he also came across such news of custodial violence taking place. And he mentioned those articles published in Indian Express and Telegraph, and he wrote a letter to the Chief Justice of Supreme Court. And he said that this letter that I'm writing, it is to bring your notice to this certain concern. Please consider it as a public interest litigation. Chief Justice also considered that, yes, it is an important matter. It was considered as a public interest litigation, and Supreme Court issued 11 guidelines, which are followed till now. These guidelines are nothing but some sort of rights given to accused person. Once a case is filed against a person, he will also have some rights. If he is arrested, he will also have some rights. So these are mentioned over here. Okay, so that is also nothing but rights, right? You have a right to life and personal liberty, right to dignity and all that stuff. So if that right is being violated, you again have a relief or remedy. You can go to the court that I was not produced before the magistrate within 24 hours. I was not allowed to talk to my advocate in person, like like privately, I was not allowed to talk to my lawyer. All these are nothing but again your rights. If that is not recognized, you have a remedy for that. Okay.
Okay. Ma'am, previously we discussed one point now, ma'am, here under limitations of this Ubi Jus this thing. The point, the maxim is also not applicable in case of public nuisance unless and until plaintiff show that he suffered more injury than other number of people of the society. So, example, I'll say I'm getting disturbed from this loudspeaker, something you imagine, okay, from any of the religion related thing, mic issue, I'm getting disturbed now. But in this case, I'm not only the person who is getting disturbed, my whole area is getting disturbed, but nobody is ready to raise the voice. But I will go to court. Then what happens? Court will not entertain my appeal, or how it is, ma'am?
Actually, there are again a lot of different provisions. We have public nuisance covered under IPC. You can go under there. Under CPC also, we have entirely different procedures mentioned. In some cases, it is being allowed. It's just a general rule that we have. Okay, there are again provisions where for public nuisance also you can go to the court and you can.
Okay, but that doesn't come under this tort, this one, right?
Yeah. Usually it falls under criminal law IPC, but under CPC also we have a provision relating to public nuisance cases can be filed. Okay.
Okay, ma'am. Okay. Yes, ma'am.
Yeah. So then you can write a conclusion that, yeah, Ubi Jus Ibi Remedium is very much important, because if someone is given a right, that's not enough. We need to make proper provisions that what if this right is being violated, like that. You can mention a conclusion. Okay, is it clear?
Yes, ma'am. Clear.
Okay.
Yes, ma'am.
So we have another concept called mental element in tort. Okay, we will continue with that in the next class.
Is it okay? Fine, ma'am. No problem.
Yeah, okay, fine.
So my screen is visible, right? Okay. All right, so let's begin with the class. So we have two topics for today's class. One is mental elements in law of torts, whether mental elements are relevant or not in fixing liability under law of torts. And another one that we have is damages which are provided, right? Or reliefs which are being given under law of torts. So these two topics we will be doing today. First we have is mental element in law of torts. Now in IPC, if you talk about criminal law, it clearly mentions that mental element is very much relevant. It's almost in all the cases it's relevant, but there can be some cases where like intention might not be as needed, even anyways, like person is punished. Okay, so mental element is considered as an essential element in case of criminal law, because we want to punish the person. Just because he was having a bad intention, he did something, it caused loss to another person, we are punishing that person. But that idea or that concept is entirely different in case of torts. So we need to understand if mental element is relevant or not in case of law of torts. Okay, so what is tortious liability in general? It is that law gave you some rights and that right was not respected by another person. Another person violated his duty that he was having, because when you are having a right, another person will have a corresponding duty so that you are able to enjoy your right. Now, when you were given a right, maybe being owner of a certain property, you were given the absolute right to enjoy that plot to the exclusion of others. And another person did not allow you to do so. That person entered your premises without your permission or without your consent. So there we can say tort has taken place, a wrong has taken place. And what wrong is it? Somebody entering your premises without your permission. What wrong is it? Just trespass, right? The person has committed trespass to property. He entered your property without your permission. Now, in some cases, right, the person has entered your property, whether it was intentional or not intentional, that might not be that much relevant. In case of crime, we have this concept, mens rea, actus rea, right? Both of them should be present. After that, it will constitute a crime. Like in case of theft, you must be knowing that if intention is not there, it's not even considered as theft. Even if I'm taking somebody else's movable property from their possession, it's not even considered as theft, simply because I was not having that mental element present. I was not having guilty intention to commit the crime or to cause wrongful loss to another person. It's that relevant in case of crime. But what about law of torts? In torts, whether mental element is needed or not, it will depend on situations. And on the basis of intention, we can broadly classify torts into two different groups. One being intentional tort, another one being unintentional tort. Okay, what is intentional? With intent you are doing, and another unintentional tort. So what is intentional tort? There can be some situations where if intention is not there, it does not make sense to consider it as a law.
Okay, it does not make sense that we still consider that to be a wrong. Take, for example, we have different torts like assault, battery, false imprisonment, intentional infliction of emotional distress. In such cases, intention is very much needed. If intention is not there, unnecessarily asking the person to pay compensation, that will not make much sense. Take, for example, a person is there who might be a police officer, and he is having a gun with him, okay, and he is authorized to hold that gun also. One day might be he wanted to get something fixed in his casual where he was going outside with his gun. Another person was very scared to see it, okay, or might be someone is an authorized, like he's having a license to hold a gun, and by seeing him, another person was so scared that he cannot file a case for assault, right? He cannot say that I got scared because this person was carrying a gun and I thought that he may shoot me anytime, he may kill me anytime. That is not a valid situation where we are asking this person to pay compensation. Why? Because intention was not present. Right? Are you aware that there are these people, I guess Sikh people, who would carry sort of a knife in their vest area? Have you seen that? Carrying knife. Yeah. Have you seen these people carrying these sort of kirpan, I guess it is called? Yeah, kirpan. You have seen. Right? So if somebody is carrying it, right, it does not mean that person is trying to assault another, trying to put that person in fear of injury or something. Okay, and if another person got scared, okay, like it's actually a situation that happened with me, that I was not aware that they carry these kirpans. Okay, when I was in school, for the first time I went to this golden temple, and I was not aware that they carry these kirpans with them all the time. So there was one Sikh lady who came to us, and she was talking nicely to all our family members and everyone. And suddenly I saw that she's carrying this knife. I was in school, I was not having any knowledge of this thing that they do. All right, and I got so scared. I thought might be she is not a good person, and I told my sister that she's carrying a knife sort of thing. And then she was like, no, it's something that they anyways do it. Right? So in that case, just because I was not aware of the situation and I got scared that maybe she can cause harm to anyone, that does not mean she will be held liable for assault. Why? Because it was not intentional, right? She was not doing anything to scare another person or something. It's just like a tradition, they follow it. And just because I was not aware of it, I got scared, that's not her problem, right? It's not justified that she would be asked to pay compensation. Okay, so there can be certain situations or certain different situations, right, wherein intention becomes relevant. If intention is not there in such a case, it will not even be considered as a tort. Okay, same may become with regard to assault, where I am just I may feel like, okay, this person is about to cause harm. Okay, there also it would intention becomes relevant. Okay, someone might be just stretching her hands or stuff like that, and another person standing right next to the person, he might be scared that, oh, is she trying to cause me harm? But in that case, she was not having any such intention, right? She was simply maybe stretching her hands. That means intention becomes very important. In every single case where a person just randomly had that thought that maybe this person can cause me harm, we simply cannot ask that person to pay compensation, right? Intention becomes very much needed over there. Same in case of battery, like you are touching another person, not just you are like about to hurt another, but you have touched the person or some physical touch is there. It might be it's a crowded train or a crowded metro.
Okay, when a person was trying to get inside it, he pushed another person, or might be by mistake that another person suffered some harm. There also intention becomes very much needed. Was it intentional, or was it so crowded that it just happened without any sort of intention? That intention becomes very much needed in such cases. Without intention, it does not make sense that we are simply making the person liable. Okay, same would apply in case of false imprisonment also. So what is false imprisonment? False imprisonment, are you aware? Soumya? False imprisonment is like by mistake, right? Wrongfully, a person is detained. Okay, might be a person is locked inside a room or something like that, but it was not intentionally done. It was like unintentional, it just happened. In such cases also, intention becomes very much needed. Like I remember we had one chapter in our English textbook in school. There one chapter was there when it was like the day when summer holidays will be announced, and all these students were asked to be present on that day. So everyone was like very happy. They went to the school, they attended the class where this holiday homeworks were also given to them, that you need to do these things and everything. Once classes were over, there was one student who went to the washroom. All right, and already classes were over, school got over, so all the other students, they were going to their respective buses or their houses. There was this one student who went inside the washroom, and in the meanwhile, right, the peon was also like locking the classrooms and everything, and after locking all the classrooms, he went to the washroom also, and without checking if somebody is inside or not, he simply locked it. Okay, that means by mistake he locked one student inside the washroom, and then he was shouting, there was no one around to release him or anything. All right, that means it was false imprisonment. That student was locked inside one very small washroom. But then, was it intentional or not? That becomes again relevant, because the person was not doing it intentionally. He was locking everything and he thought that might be all these students already left. There is no one. He did not check it. He simply locked it. Okay, so in such cases, intention becomes very much needed, whether something is done intentionally or unintentionally. Okay, or might be like inside the classroom, classes were over, everyone left. Maybe there was one very like a small student was there, he was sleeping in the bench, and the peon came, he just checked everywhere, he did not notice anyone, he simply locked the classroom. There also, he was not doing anything intentionally. There was false imprisonment, but then it was not intentional. Right, so intention becomes very important in a lot of different torts, where without presence of intention, it does not make sense to ask a person to pay for compensation. Okay, like pointing a gun at another person with an intention to threaten the person is assault and falls under intentional tort. If I'm doing it intentionally, then in that case it becomes tort. But maybe I was simply testing the gun inside the office or something. There was another person and he got scared. There it was not done intentionally, right? I was simply checking how the gun looks. In that case, it will not be considered that intention is present. Okay, so for most of the torts, intention is not relevant, but there are certain situations where we need to consider intention. Otherwise, it will not be justified to simply impose compensation on the person. right? Simply making the person liable does not make sense in all the cases. What is unintentional tort now? In unintentional tort, defendant causes injury to the plaintiff, but without any malified intention. Whatever I have done, for that, because of that, another person has suffered loss. Loss is there, but I have not done it intentionally. I was not having any bad intention. But even in such a case, I can be held liable, or I may be held liable. Why? Because mental element may not be that much relevant. What is relevant here is another person's legal right was violated because of my act or omission, like we discussed in essential elements of torts as well. Some act or omission is there. Because of my act or omission, another person's legal right is affected. Legal right is being violated. And from there, he is getting some sort of remedies as well. So if these three things are present, intention might not be relevant. I can be anyways held liable to pay for the compensation. Like if you remember that Ashby versus White case, a person, a qualified voter was wrongfully restricted from giving his vote. But then whoever was the person there, the presiding officer, he was not having any bad intention as such. But still he was held liable to pay compensation. Why? Because legal right of a person is being affected just because of act of the presiding officer, right? So we are concerned with violating legal right of a person, loss suffered by a person. We are not that much concerned with whether it was done intentionally or not. Loss is being caused, that is enough. We can ask for compensation. And this is common in case of torts. In most of the torts or most of the wrongful acts, in fact, intention does not matter as much. Okay, so take, yeah.
What if a person knows that, for example, a man would say plant a pot of plant in his balcony, and he is aware of the fact that if a little wind blows, so the pot can fall down out from the balcony and could injure the person who is walking inside below the balcony area. And it happens. So will it be from an intentional or unintentional?
See, in such,
or it is a crime, or it's a crime under the torts, or in other way to go.
Okay, so see, if again that pot falls and another person suffers injury, now again it depends whether it was a plastic pot or it was of some other like heavy material. Okay, so depending on the loss, maybe the person got severely injured, he can file a criminal case also under IPC, right? Hurt, under hurt also he can file a case. Or in case of torts, if we take the example, we are anyways expected to take the like reasonable precaution, whatever we are doing. If we are planting trees, doing gardening and stuff, we need to be a little careful, right? Again, there is one concept called occupier's liability. Okay, being the occupier, being the person having control over this balcony, right? It is expected from the owner that we take the reasonable steps. If we are keeping pots over there, we need to be a little careful to ensure it does not cause loss to anybody else walking there. If it causes, case of negligence can be filed that we were negligent in keeping those pots in the balcony. We should have taken proper care. All right. And plus, when you are residing inside in like a house or in an apartment, in your balcony, if you want to keep pots and everything, you are also having an obligation towards people who might be entering the apartment. Okay, so if anybody who is entering or going out, it falls on that person's head, the person suffers injury, case can be filed. All right, but it has to be like a normal situation. Like if you remember in
one case of negligence we discussed that it can be like act of God also. One neighbor was there whose wall collapsed and the neighbor's kid died. Because of it, he filed a case, and the person claimed that no, it was because of rainfall only that this wall collapsed. But court said that no, this rainfall was normal rainfall only. You only did not do the construction properly. Okay, so in those cases, if it was like a normal situation where just because of a little bit of wind, it just falls, the person, owner, will be held liable that you were negligent in keeping those pots. So the person will be held liable, he will be made to pay compensation. But it was because, if it was because of some act of God, might be like a very heavy earthquake or stuff like that, which was not expected, and even after keeping it properly, safely, it just happened. In such a case, the person can ask for the exception that no, it was because of act of God only. It was because of this severe earthquake that this entire building only got damaged or stuff like that. Okay, so there he can claim the exception, but otherwise the person will be held liable, because when we are keeping something within the house, we need to ensure it is safe for people around us. It's safe for the visitors, the licensees, or other people who are entering our property.
So basically, it will come under intentional tort. He was aware of the fact that the wind might come and the pot might fell to the property. Might also got injured to another.
It will be unintentional tort, because your intention is not relevant. Whether you kept the pot there just because it looked good, or you kept the pot so that that specific person would suffer injury, that does not matter. Why you kept the pot does not matter. What matters is this person suffered loss, and it was because of a normal situation only it happened. So that would fall under unintentional tort. Your intention there is not relevant. Whatever might be your intention, good or bad, does not matter. What matters is this person suffered loss. Okay, and you did not keep the pot properly. That is enough to make the person liable for negligence. So it would fall under unintentional tort, where intention of the person does not matter why he kept the pot there. Okay. Is it clear?
Yes, sir.
So unintentional basically means intention of parties is not relevant. What matters is that loss is caused to parties. And one, so this duty of care, which are reasonable and prudent men. Like, so duty of care we are having, like if we are keeping a pot, what a reasonable or prudent man would do. A reasonable or prudent man would see whether there are proper, maybe some grill or other stuff is there or not. If not, simply in an open space, they would not just keep a pot like that. Right? A reasonable or a prudent man would not do. If someone is doing, that means they are being careless. Person can be held liable. At the same time, there are certain welfare legislations. One very good example is Motor Vehicles Act 1988. Motor Vehicles Act is a welfare legislation. It talks about welfare of the people, of the public who are on the road, right? That those people should not suffer unnecessarily. And there, are you aware there is a concept called third-party insurance?
Yes.
You are aware, right? So third-party insurance, is it mandatory or is it optional? Buying third-party insurance.
It is optional.
Other insurances are optional, but third-party insurance is mandatory. Okay, whether you buy a life insurance or not, that's optional. You can decide whether you want to buy an insurance for your vehicle or not. That's optional. Okay, like loss to the vehicle, that's optional. But third-party insurance is mandatory. You need to buy it only. Without a third-party insurance, if someone is riding or driving a vehicle, that's a criminal offense. Okay, so it is mandatory. Now, in case of Motor Vehicles Act, you will see that if there is a road accident, okay, and because of that someone suffers maybe permanent disablement
or a person dies, an amount of compensation is given. 25,000 in case of permanent disablement, 50,000 in case of death. Their intention, negligence, or other things does not matter. What matters is the person died or the person suffered permanent disablement. If those situations are present, person will have to make the compensation under third party insurance. Okay, that means intention of the parties, who was being negligent, who was being careless, nothing matters. Why? Because main aim of this act itself is welfare of people. How can we give maximum benefit to the people? So if someone has suffered like extreme loss, you need to pay that minimum amount of compensation anyways. That is unintentional tort, where intention does not matter, but there can be some other situations where intention matters.
Okay. Ma'am, I have one more question.
Yeah.
What if a person is playing with a loaded gun in a public place and it leads and by mistake or unintentionally fired, which further leads to the death of the person walking over the street? Even in the case of minor and versus the case of major, what would be the consequence of each act?
Yeah. In case of minor, right? Again, the parents are having an obligation that they are keeping these things safely. Okay. In fact, there was, I guess, one case or an example that I came across that a minor was given a gun, but then the father realized that, okay, might be it's risky. So what he did is he took the gun from the minor and he simply kept it in the storeroom. All right, and because storeroom was anyways accessible, minor simply took it from there and he killed another person. All right, so there the parents, right, they need to ensure that minor is like these things are kept safe. All right, these gifts should be kept safe and it should not be accessible to the minor. Okay, and anyways, if you are playing with a gun or something, a person dies, again, under IPC also we have provisions, right? Homicide we have provisions, so there also the case can be filed. Rather than filing it under torts, person would file a case for homicide as well under IPC. If a person dies like just because he was playing or doing something with the gun and then suddenly a person is killed over there, or maybe he was taking the gun and fighting with a person dies over there, right? In those cases, that provision also we are having. And anyways, like minor over there, minor would be exempted, but how did the minor get the gun, right? There we can file a case against the father or the guardian under whose custody minor was, that they should have ensured that these things are not accessible to the minor. It should be kept safely away from the minor. So like that also we can proceed against the parents. Okay. In case of major, mostly people would file a case under homicide. Under torts, see again, like people usually would file under there, but yeah, you can file it that if you are keeping some guns or something, you should be a little careful, right? If you are not being careful, again, for negligence case can be filed that you are simply like a loaded gun, you are simply casually holding it and then a person died over there. You can file a case, and again, depending on the loss suffered, compensation will be decided and amount will be accordingly paid, because whether you are playing with it, you are carrying it, you are transporting it, we need to be a little careful in dealing with those stuff, right? So there again, negligence situation may come, that what a prudent man would have done, right? A prudent man, knowing that it's a loaded gun, they should have been a little careful. If the person was not careful, that means he's not doing what is expected out of him, right? So that person again becomes negligent over there, that what minimum expectation was there from him, he is not able to fulfill it. So he can be held liable for negligence over there, that while carrying it, while playing with it and stuff, he should have taken a little more of, like he should have been a little more careful over there. Okay, is it clear? If you remember the essentials of intention also there as well, we have seen, right, that you had a duty and that was like a expectation out of you and you failed to perform that duty. So you had a duty that whatever a reasonable or prudent man would have done, how they would have handled the situation, that is expected out of us. If we are not able to do it, then it's like we become liable under that, right? So that is like intentional and unintentional torts, that in some cases intention becomes relevant, but in most of the cases intention does not matter. What matters is there was act or omission, violation of legal right of parties, and some remedies are coming from there. Now, mental element in law of torts. What is mental element now? We have two things over there. One is motive and another one is intention. Okay, so motive means the main reason why we are doing it, and intention means like I intend to cause loss to another person. Okay, I intend to enter someone's property without their permission. I intend to open somebody else's gate and enter their property. That is intention. Intention is like what I want to do, short term. Right? Short term, what I want to do, I want to enter someone's property without their permission. But what is my motive? My motive is that I want to enter their property, make some noise and disappear. And I want to repeat that thing until and unless those people are scared that might be there is a ghost and they would vacate the house. Right? That means my motive is that they should be scared that might be there is a ghost and they should vacate the house. But what is my intention? I want to enter their property without their permission. So when we talk about mental element, there are two things, intention and motive. Intention, you can say it's the short-term thing, what wrong or what wrongful act I want to do. Motive is what is my ultimate purpose. Like in case of crimes, you will see like movies or CID and all, if you see, if a crime is being committed, the investigating officer, they would try to analyze the situation, be like, okay, who would have got benefit or who would probably get a benefit if this person is killed. That means they try to analyze who may be having a motive to kill this person, right? What is the ultimate benefit that a person is getting because of this person's death? To fulfill that motive, maybe some intentional thing has happened, killing of a person, right? So in case of torts as well, we have these two things, motive as well as intention. Intention is short term, motive is long term, what is the reason for doing that wrong. And when we are deciding the compensation to be paid, whether or not compensation should be paid, in those cases, motive may not be relevant. What is relevant is intention. Okay, take for example, if there is a situation of assault, battery, false imprisonment, in such cases, right, what is relevant is what is the intention. Okay, there was one case for false imprisonment, if you remember, Bhim Singh MLA versus state of Jammu and Kashmir. Have you read that case? MLA was wrongfully detained in prison. He was not allowed to attend the assembly sessions. Do you remember that case? I think we discussed it in that legal damage part. Okay, what happened is there was an MLA, Bhim Singh from Jammu and Kashmir, and during this assembly sessions, right, he was about to go to the session and he was about to attend the session, but the opposition, they wrongfully planned everything with a police officer and he was wrongfully detained in the prison. He was not even produced before the magistrate on time. Okay, and he was detained until and unless this assembly got over. When this session got over, he was also released. That means it was a case of false imprisonment. Wrongfully, he was detained in the prison. Okay, wrongfully, he was detained in the prison. So there, in order to punish, okay, in order to punish the parties, what is relevant is intention is relevant, motive is not relevant. Okay, and what is intention? That they detain this person without any valid or lawful justification. They detain the MLA without any valid or lawful justification. That is enough to file a case for false imprisonment against the parties. But it might not be relevant that why was the person detained. Maybe he was detained so that he cannot attend the session, he cannot raise his voice, he cannot give his vote, but that would not be considered by court because intention is more important. Okay, and because of presence of that intention itself, we can decide whether it's a wrong or not, whether person is entitled to compensation or not. So motive might not be relevant in deciding whether a person will be liable or not, whether we need to ask him to pay compensation or not. Motive may not be necessary. Wrongful act does not become lawful just because motive was good. Okay. Hi, Arma.
Hi, ma'am.
Hello. Yeah, so we are discussing mental element. Okay, and there we are discussing relevance of motive and intention. So motive is very much needed or very much relevant, and just because your ultimate motive was some right thing, that does not make your act right. Okay, what matters is your intention. You did some wrongful act, that matters. Even though your ultimate motive was good, that does not matter. Okay, like a person may say that, okay, fine, I want to rob a bank. And why I want to do it, maybe I want to take that money and distribute it amongst poor people. But simply because my ultimate motive was right, that does not make the offense like a right thing, right? I will anyways be held liable for robbery because I'm doing a wrong thing. My intention is wrong there. I want to wrongfully rob a bank. Whatever might be my motive, how good does not matter, right? So motive is not that much relevant. Whatever is unlawful, that is anyways unlawful, and my intention is what matters, right? There can be certain situations where intention is necessary, some situations where intention might be not necessary, but then motive is not that much relevant. Okay, then we have two more concepts: malice in law, malice in fact. Malice is like the wrongful thing that we have, right? Malice in law signifies that wrongful act done intentionally without just cause or excuse. I have done something wrong and I don't have a proper justification or a valid reason that I can prove before court. Okay, I cannot justify my act before court. Like I cannot justify that it was maybe a statutory authority. Under statutory authority, I have done or something. Okay, I don't have any such justification to defend my wrongful act. That becomes malice in law. Malice in fact or evil malice means evil motive for wrongful act. When defendant does a wrongful act, because I have some ill will, I have some wrong intention with that I am doing it. That is malice in fact. That when I'm doing a wrongful act, maybe I'm entering someone's property, I have an ill will that these people should be scared that is it so easy that any random person can enter my property, and they will be very much scared. They cannot keep their doors open in the evening because they will be scared that next time anybody may enter our property. That is malice in fact, that I have some ill will in my mind while doing it. Malice in law as in before law, when a case is filed, I am not in a position to justify it. I cannot prove that it was because I had the authority to commit this wrong. It was a statutory authority. I cannot do that. Okay, so that is malice, or the presence of evil intention or ill will while committing a wrong or while doing an act. Is this part clear? Soumya, is it clear? We also have one case relating to this, Town Area Committee versus Prabhu Dayal. It's a case of 1975, wherein plaintiff made certain construction without complying with provisions of UP Municipalities Act. So usually when we are doing construction, even though it's our property, we need to take some permissions, approvals, and there will be certain guidelines that we need to follow, like how much of space should we be leaving in all the sides of the house and other stuff, right? We need to do some soil testing, this, that, so many formalities. And those will be decided by the concerned state's law, right? So in this case also, there was UP Municipalities Act, under which there were certain rules or regulations which were to be followed, and these provisions were not followed while doing this construction. The defendants demolished the construction. The plaintiff sued the defendant, contending that the demolition was illegal, as some of the officers of Town Area Committee were acting maliciously. Okay, that means if I am doing some wrongful, like some illegal construction, and the Town Planning Committee or the authorities, whoever are there, they decided to demolish my property only. But there were other illegal properties also. There were other illegal construction also. They simply decided to demolish only my property. Why? Because maybe they were having some enmity with me. Just because they simply targeted me, demolished my property, I cannot go against them. I cannot file a case that they were having like a illegal motive or something like that. They wanted to take revenge, so only they demolished my property. But in the same city, there are so many illegal constructions going on. That will not be justified. Why? Because whatever I have done, that was anyways illegal, and these authorities are having the right to having the statutory authority to demolish illegal constructions. So whatever might be their ultimate motive, whether they wanted to take revenge, they wanted to teach me a lesson whatsoever, does not matter, because they are the rightful authority having this right. They are being given this right, so they can take the action against me. Okay, it will not be much relevant over there. So this basically indicates that, again, intention becomes relevant. Intention may be considered by courts while deciding liability of parties, but motive may not be necessary. What was the ultimate motive? Whether it was good, whether it was bad, that does not matter. Whether my act was intentional or not, that may matter in some cases. In some cases, even that may not matter, because in case of torts, the main aim is that we want to provide compensation to parties. And why is compensation paid? Because just because of my wrongful act or omission, someone has suffered loss. Might be otherwise this person will have been in this position. Because of my wrongful act, he came down to this position. So there I have an obligation to pay him compensation, make this wrong good, and bring him to the same position where he would have otherwise been. Okay, and just because we don't want to punish the person for the wrong, but we simply want to undo or try to compensate and balance this out. That's why in case of torts, intention is not as much relevant as it is in case of crimes,
Because in case of crime, we want to punish the person and we want to reform him, right? In India, the basic principles which we follow is reformative theory and deterrence. We want to set it as an example for other like-minded people. But in case of torts, that's not the situation. We want to simply repair the loss that the victim has suffered. So mental element might not be relevant because whatever may be the intention, anyways, loss is suffered. So we need to make that loss good. We need to repair it by paying compensation. Okay, so this is about mental element, where we have some torts where mental element may be relevant, some torts where it might not be relevant, and we also have intention plus motive. That just because my ultimate motive was good, it does not make a wrongful act right. But in case of intention, that might be considered in few cases like assault, battery, mayhem, or in case of false imprisonment, situations like that, it may become relevant or necessary for parties to consider.